welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Peter Roscher, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hi there. Welcome to another edition of Reed Smith's Arbitral Insights podcast series. My name is James Wilne, and I'm a partner in Reed Smith's Energy and Resources Group, based out of Dubai, where my area of expertise is the resolution of disputes on high-value infrastructure and energy disputes by arbitration. It's my absolute pleasure to be joined today by Rohit Singhal, who is the Managing Director and founder of Masin. Rohit has over 24 years of international experience involving construction contract disputes, expert testimony, and project management. He has extensive arbitration and appointment experience and has been appointed as an expert witness more than 50 times on delay, technical, and quantum matters for construction arbitrations. Rohit, welcome to the podcast.
Hi, James, and thanks a lot for inviting me to this podcast. It's my absolute pleasure to be here talking to you and to the other audience who are going to listen to me and you on this important discussion of construction export related issues. Thanks a lot for this invite. Thank you.
Thanks, Rohit. All right, absolute pleasure. So today's discussion with Rohit will very much centre on his perspective as an expert witness within construction disputes resolved by arbitration. So Rohit, initially, what are your views on what tribunals want to see from the experts in both written reports and indeed their oral testimony?
So, James, you see, why are the experts engaged by the parties in the tribunal is primarily to help the tribunal to come to a right decision, a right award, and to decipher the dispute in such a fashion where decision making becomes more easy and the right decisions are taken. Experts are basically people who understand their field. For example, in construction dispute there are complicated engineering matters, there are complicated delay matters, quantification matters and all, which probably the tribunal would need an external help of a person like an expert to for them to come to the right decision. So therefore, what tribunal expects from an expert is, number one, independence, because the duty of the expert is not to the party who is engaging him or her, but it is towards the tribunal, so that they can come to the right decision. They get to know what is right or wrong. For example, if you are acting as a delay expert, the tribunal would like to understand that out of hundreds of or a kitchen sink of delay events or issues which are pleaded by the parties, and which one of them is the actual critical delay, is the actual reason for causing delay to the project. If you are acting as a quantum expert, the tribunal would like to know whether the evaluation and the quantification of the claims and counterclaims done by the parties, are they right, are they properly supported by documents, evidence, and if not, then what should be the right quantification. So therefore, two most important things which tribunal is looking for: one is of course an independence, because they would not like the expert to be biased and supporting the party who has engaged him or her, and secondly, a proper and an elaborate, detailed and easily written which a report which can be easily understood by the tribunal, so that they can come to the right decision. So same way on the testimony part, when you are going to stand in front of the tribunal and get cross-examined, what tribunal expects is that if the expert has submitted a report and he has taken some viewpoint and some stand, then he or she is able to defend that stand in the during the hearings, during the cross-examination and oral testimony. And as part of that oral testimony, the expert can also explain to the tribunal and to the lawyers and the parties that what are his viewpoints and how he has come to that final ultimate conclusion which he's drawing up in his report.
No, I think you're absolutely correct there, Rohit. And I think my experience is clear and transparent views are absolutely vital for party appointed experts. And I think sometimes a kind of willingness to admit when perhaps you don't know the answer or you're not clear, and say that, don't actually volunteer something that you might actually believe in. I think tribunals actually accept and take on an expert's credibility if they're happy to say, well, we couldn't find an answer on this one. We'll try our best to assist the tribunal, but an actual clear and final answer on this point wasn't actually available. And I think that actually buys experts more credibilities with tribunals, rather than actually try and volunteer information that they're not particularly clear on. And I think you raise a really important point, and it kind of leads into my second question. The independence of a party-appointed expert, as you rightly say, your duty is inherent to the tribunal. You're there to assist the tribunal. But what challenges does that give to an expert when, in fact, he's receiving his direct instructions from one particular client on one particular side of the dispute? What issues does that give you?
So, James, you have put a very right question, an appropriate question. That what are the challenges when we as experts try to be independent and have to be independent, and on the contrary, we have an instruction and payment coming from the client. So this puts definitely us in a kind of a conflicting situation, wherein the client who is making our payment for the fee would expect us to support their case. But then that's where an expert has to understand that, as I said, his duty or her duty is towards the tribunal and it's not towards the client who is paying. So therefore, it has to be explained quite clearly to the client who is instructing you that what are the duties of the experts. Definitely a lot of this comes from the instructing counsels or lawyers who are issuing the instructions. But still, I have seen instances where the clients who are probably getting first time into arbitration, or they are not very experienced on the concepts of independent expert, they try to argue that how can you come out with a issue which is probably against their pleadings or against their position. But that's where a good expert and an experienced expert would explain to the client, and also the lawyers would also join with the expert to explain to the client that the expert has to be independent in case the report is not independent and it is purely and out is supporting the case of the client, even though the client's case is wrong. The report is going to be discredited and probably rejected by the tribunal, and then the damage which is going to be caused to the client's case would be far more than if you have an independent expert report. So the challenge which comes to us is that, first of all, making the client understand the role of an independent expert. Then the second challenge which comes quite often, especially when you are acting for the respondent and even in claimants cases, the availability of the documentation. Construction contracts are quite complex and they are very document heavy kind of contracts. A lot of exchange of letters and reports, etc., is there. So what I have seen is that a lot of times the record keeping is bad, details are not available, and I have been in instances where I have to submit a report to the tribunal where I clearly say that I'm not able to give assessment on a particular issue because of the non availability of sufficient documentation. So that is the second set of challenge which generally we see in construction contracts and while acting as construction experts. But generally these are the two broad level and high level challenges which we see when we are acting as experts.
Yeah, and I think the point you raise about the new client to arbitration is a really valid one, because the reality is a client will see, well, I'm paying Massin's bills, aren't they on my side, aren't they on my team? And I think that's where the instructing lawyers such as myself can actually support and assist you guys in actually explaining that independence. Just because you've got a direct engagement with the expert, it doesn't mean they're on your team. And actually, you want that independence. You want that set of third eyes on your claim or indeed your defence. I personally get more nervous when an instructed expert is is almost too willing to assist, that actually gets my guard up. Now, I don't mind, obviously, if their keenness to assist is supported by valid backup, by valid evidence. But when I can see an expert is almost trying too hard to support the client's claim, that makes me inherently very nervous, because I know there may or may not be a time where he or she has got to give that evidence to the tribunal, and not to me. And that's the real crux of things. I always look 6-7 months down the line as to whether or not the expert reports, the kind of conversations I'm having with an expert, say in January, can they be tested at a hearing sort of 9 months, 10 months down the line? So you're absolutely right. That independence, I think, is absolutely paramount to an expert throughout the proceedings. And that kind of leads me again nicely into sort of my next question. So where have you seen kind of good examples of party-appointed expert performing well, and where, again, not without giving any names away on this one, but where have you seen an expert who's got it wrong, and why have they got it wrong?
So, James, there have been several instances where we have seen experts performing good, experts coming to the help of the tribunal. They are quite independent. The reports are quite well laid out, easy to explain, and easily written, and kind of touching to the exact issues which are there in the dispute. Recently, I was, in a arbitration related to a building project. The dispute was related to the last stage of completion related to the punch list. So majority of the building was constructed, and it was kind of a delay in the punch list, which was hampering the issuance of the completion certificate. And the punch list was running into thousands. So imagine 99% project is completed, and it's only the last set of punch list points which are causing problem. And it's not that typical project where you have a typical critical path and analysis of delay. It's basically assessment of the punch list, and then when you have the last set of small issues which are remaining, it's very difficult to come out with the critical path. But there, we could see that the position of the parties, both sides arguing that the punch list was issued late, or the other side respondent saying that the claimant took time, or the contractor took time in clearing the punch list. So there, I what was essential was to analyze only that set of punch list related delay rather than the overall project delay. Now, what I found was that unfortunately, the expert on the other side probably analyzed the delay from the start of the project all the way till the 99% stage, which was not an issue under dispute. The dispute was primarily on the punch list related aspect rather than any delays which are taking place during the construction of superstructure, substructure, etc., etc. So there you see, what is important is that the expert has to understand that what is the dispute all about. Now in case if I go as a planning expert and a delay expert, and I do not understand what the dispute is all about, and I do not understand what are the reliefs being claimed by the claimant and the respondent, and I come up with an expert report which is completely 180-degree to what is being claimed as a release by the parties, the expert report is not going to be of any help to the tribunal. So this is one typical example where I'm trying to point out that the expert has to understand that what the dispute is all about, and then has to then give his or her report in a fashion that which deals with the issue of dispute, rather than talking of things which are not under dispute.
I was literally just going to say the same thing towards the end there. So my personal experience of where things start to go wrong for an expert is when they start volunteering answers to questions which they shouldn't know, that they were not even instructed on, or it's simply not within their realm of awareness. And that's the real big one for me, where I've seen a fantastic expert who's given me fantastic, helpful reports, independent, impartial, helpful, clear, has met with the other side's expert, has resolved issues between the two, clear as crystal all the way through the process. But at the time of oral testimony in the box, under some pressure, it's not a particularly pleasant experience giving oral testimony, well, for most people anyway, but suddenly being asked questions which quite clearly they would not know the answer to. As I say, either they weren't instructed on it, or they simply weren't there at the time when the facts of the question arose. But all of a sudden, in the kind of the heat, the pressure of a live tribunal, suddenly volunteering answers that one make no sense at all, or are so inherently wrong as to potentially be damaging. And that's the big one for me. And I have to say, even with seasoned experts, the one thing I do say to them before they go in is just answer the questions that you can answer. Don't feel the need to volunteer information that you don't know. As I said at the start of this presentation, more often than not, you will gain more credibility in the room if you say, I don't know. Why would I know? I wasn't there. I wasn't instructed on this part. And that's the real trap for me, I think, that experts can actually fall into. Finally, then, and this is more of a personal point for me going forward. So, in terms of your client instructions, where you're instructed by myself or the lawyers, what do you like to see in your instructions to an expert? What are the key things you like to see in that instruction document?
So, James, what we are looking for is a clear set of instructions. What I've seen quite often is that the instructions are not clear, and then as we move and we prepare our draft report and submit our report to for factual checks and for to the lawyers to review, you find that additional instructions are being given, or else what is happening is that the instructions sometimes are not in sync with the matters of dispute, and they are generic instructions which are not helpful at all. And many a times I've also seen that sometimes, let's say if I'm acting as a quantum expert and I'm instructed only to assess the 4 or 5 claims, and the other set of 4 or 5 claims I'm not instructed to assess, then of course that also puts you in a little bit of awkward situation during the oral testimony, where you say, I have been instructed only to assess 5 claims, I have not been instructed to assess the balance 5 claims, or I have been instructed to assess claims and not the counterclaims. So, what we are always looking for is a clear set of instructions which are in sync with the dispute, which are in sync with the reliefs claimed by the parties. And as part of the instructions, we also look for what are the documents to be relied upon. Like for example, in case it's a memorial type of submission arbitration, then what all documents are available. Many a times, the expert and lawyers are engaged together in a memorial type of submission. So there again, it becomes kind of difficult for the lawyers to give instructions in the beginning, but then as they go through the case, they develop the instructions. So in nutshell, what we are looking for is a clear set of instructions. What is required from the expert, what should be his or her outcome and conclusion. That's what is we are looking for.
I think you make an absolutely fantastic point about the evolution of the instruction document between the client and the expert. Because, like you say, sometimes at the very start of these projects and these disputes, we as the instructing client on behalf of the client, we're not hugely clear on what that instruction is. It's early days, we know there's been some problems, we know there's been delay, we know there's probably some costs from that delay. But in terms of where we should apply the expert, it's unclear to us. So I think you make a great point that there needs to be an evolution of those instructions as you go forward. And I find the best experts that I work with will actually put their hand up sort of 3 to 4 months in and say, James, look, our position has slightly changed in terms of what you've asked us to do. It's probably time to take a bit of a sense check on those instructions and get those amended, because you're quite right. If you get to the final hearing and, potentially the other side are speaking things about what you might not even looked at, it can all get very embarrassing. So that evolution of the instruction document, I think the helpful expert who reaches out to the client and asks for updated instructions always goes down fantastically well with me. I think that's the nature of a true partnership. So that's all of our questions for today, Rohit, and I have to say that was fantastic. Really, really, really helpful. So thank you very much for coming in today.
Thank you, James. It's been an absolute pleasure to be part of this podcast, and thanks a lot.
So that concludes today's episode of Arbitral Insights, which is an insight into how a construction expert is instructed on matters. Hopefully that's of use to listeners, where of course this can be picked up on wherever you get your podcast from, be it Spotify, be it Apple. Thank you very much and see you all soon.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the costs of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.